number 23, People of the State of New York versus Charles Smith. Counsel?
Thank you, Your Honor. May it please the court. My name is Craig Stewart. I'm representing the defendant appellant, Charles Smith. I'd like to reserve 2 minutes.
You may, sir.
Thank you. The issue presented by this appeal is whether the passive placement of a hand out of sight satisfies by itself the display element of Penal Law 160.154.
Well, you phrase it as being passive, but is that one of the things that we have to look to the record for, is if there's evidence that, in fact, it wasn't just passive by the victim's testimony, for example?
Yes, Your Honor. I mean, that is what I think the court needs to do, is to look at the record.
So if it's more than just, he walks in, his hands are under his sweatshirt, and he says, "I've got a gun, and I want you to give me your money." If it's just that, it's not display, right?
That's right.
Okay, but if it's more than that, and the question that we're looking at is how much more than that is necessary, would you agree with that?
I think that's right, Your Honor.
Okay.
I think that is the question that the court needs to look at.
Well, aren't you in essence asking us to overturn Lopez?
Absolutely not. I'm asking you to reaffirm Lopez. If you look at Lopez and Mendez, the court in Lopez was clear. And when I say Lopez, in this instance, I'm referring to the written decision, which encompasses obviously the 2 companion cases.
We understand.
It was clear that a volitional act needed to occur. In Lopez, the defendant announces this is a stick-up, and as announcing it, puts his hand into his vest as if he had a gun. In Mendez, by contrast, the man on the stoop has his hand under his shirt, his right hand under his shirt, which is the testimony here, and the court says that's not enough.
Well, the other man in Mendez was another man, right? And the problem there was, the court found there was no accomplice liability. Your client was the only person in this cash register place, cash checking place.
And we have facts too that are a little bit different. The statements are more affirmative. He says he has a gun. He's going to shoot her. The cashier says he says that 2 times. Also, he's holding his hands under a hooded sweatshirt, and she characterizes like he has something there.
Well, if I might take both.
Well, but just following it all the way through, the language in Lopez doesn't seem to, the way I get it, it doesn't seem to really, it says it refers to an object need not be closely resemble a gum, a firearm, or a distinctive shape, and it may be a hand consciously concealed in clothing. And isn't that what we have here?
We don't have a hand consciously concealed in clothing that is linked to the statement, and that is what's critical in Lopez, that linkage. In Lopez, he announces a stick-up, and at that time sticks his hand in his vest. In this case, he simply happens to have his hand under his sweatshirt. In fact, Your Honor...
I'm sorry, didn't he say, "I have a gun"?
He doesn't say anything about where his gun is.
I see.
He doesn't gesture. He doesn't point at it. He doesn't look at it.
So
And
you're
it
saying
is-
there has to be a volitional act.
Exactly. That links it to the statement, the threat, which this court has held as insufficient. And in this record, and this is fascinating in a way, she is asked what happened. You look at 32 and 33 of the appendix. The prosecutor says, "What happened?" And she gives a long, sort of a kind of a monologue that's uninterrupted by questions. There's an objection and the judge intervenes, but it goes on for really 2 pages. She recites the entirety of the interaction. Not once does she mention the placement of his hand.
But
Not a
doesn't she say, I didn't see the gun, but he was doing this, indicating, and of course, we weren't in the courtroom, so we don't know what that is, but
Well, we do know.
can't a jury infer that he was doing something?
Well, in fact, we know what he was doing because the trial judge described for the record exactly what he was doing. And then he describes it. Her hand is underneath her shirt at her waist. On cross-examination, she is asked by defense counsel, and then he reached under his hoodie. She says, no. No. His hand was like this. The
She
hoodie was,
said, he showed me like this.
yeah, but that's Your Honor, respectfully, that's a language issue. She said, like he got something in there, and then if he showed me like this, that when she is asked to describe exactly what he was doing, and when the judge and prosecutor recite that, they do not say he moved his hand, he turned, there's none of that. They recite only.
Well, that would be easy. I mean, if she said those things, but we're looking at the record that we have,
Right.
and the question is there legally sufficient evidence?
In
And
respect-
could a jury from this testimony could a reasonable jury have reached this conclusion?
And that's exactly the question, and we should not be left on this thin of a record trying to reach that conclusion. We are all then, if we're doing that, imparting to the record testimony that is not there.
But counsel, doesn't she also say, this witness, she thought she saw him holding something?
She said, like he got something in there, he was holding, like he got something, but the court says, because there's clearly an issue with the way she's using the language, the court said, describe exactly what he was doing. And the judge, at the end of the case, says, we tried to verbalize what she showed. What did the judge say then? The judge said, her hand was under her shirt.
So let me ask you this. So would you say then that it boils down to our view of whether it would be reasonable for the cashier to think that he had a gun?
No, well, yes, in the sense that that is the holding of Lopez. No, in the sense that there is nothing in the record.
Well, you're saying that the record doesn't support that, but that's the question.
That is the question, that under the
So
circumstances.
it's the reasonableness of
there must-
objectively,
there-
let me just finish it.
Yes, sorry.
Objectively, that's okay. Objectively, the objective man standard, whether or not it would be objectively reasonable for her to think that that person had a gun.
And there have to be, to do that, to satisfy that standard, there must be a volitional act and linkage to the threat. And that is not present. And I want to go back to a question I got asked earlier about the Mendez case, because I think it's important. Mendez was not just about accomplice liability. The court did focus on that, but also said, and he did not conspicuously, consciously display. There seems little doubt that in Mendez, had that man on the stoop moved his hand or taken an action, the court would have found.
So does your rule boil down to if the perpetrator has has a hand under a shirt, jacket, sweatshirt, whatever it is that is otherwise, to the extent that someone could see the hand underneath, even if they're not seeing what they may or may not be holding, right? If you walk up to the person you're going to threaten, that doesn't your rule boil down to having to say, I have a gun in my hand, which is exactly what we've said you don't have to have in these cases?
You do have to do two things. I mean, there needs to be a threat, there needs to be a volitional action, something, and that needs to be linked to the threat.
Well, I'm saying that, but the volitional action could have occurred, to the extent that you're arguing that there's got to be some movement that could have occurred before you show up, right? You
But
place
doesn't-
the gun or the weapon firmly under let's just say a shirt, under the shirt, and then you approach the person.
Then
Need
it's
not
not-
move. Now you're just going to make the threat verbally.
Then it's not objectively reasonable. The display needs to take place in the presence.
But that's what I'm saying. Isn't your rule then that in that kind of a case, the perpetrator has to say, I have a weapon or I have a gun or I'll shoot you, something like that?
The perpetrator needs to say that and needs to do something. There needs to be,
So if the perpetrator says, I'll shoot you,
that's not enough. That's a threat. And in fact, that's something the court specifically addressed in Lopez by saying, it may be just as frightening, but that's not enough.
So would it be enough for the person, if they had a weapon in the waistband, to pull the shirt up a little and kind of show?
Yes.
That would be
be a
enough.
volitional act linked to
well,
the
that's
threat.
clearly a display, right?
And that is the display.
What
Here,
if he has his hand under and he just kind of, moves it
that,
to
the
show
courts have
that-
held, and that is enough. That's an action linked. That's your
What if he
test.
just looks down where
That
his hand
could be
is?
enough, depending on, obviously, the facts, because, if it's a random movement of the head, but if he does it in such a manner as to call attention to the weapon, then perhaps, yes, that's an action.
But isn't it then coming back to, if you don't have to reach your hand in, we don't have a reaching in rule, and we have testimony here which you describe as a language problem, where she says on the record he was holding something, we're going to parse that out and reevaluate it and say no reasonable jury listening to that and hearing the judge's rendition of it could conclude that that was some type of act, a pointing of something that gave the impression he was holding something with his hand in his waistband saying, I have a gun, that wasn't legally sufficient.
Your Honor, the fortuity, his hand, why, we don't know why his hand's under his sweatshirt. He's homeless, it's November, he walks in, his hand is there. He doesn't move it. There is no testimony to that effect.
But we
And
don't
so
really
we're
have
left-
a moving the hand rule, nor I think would we want a moving the hand rule. So if the
Well, then-
testimony is, because clearly if I have my hand in the vest and it's pointing and I don't put my hand in to point it at you, but it looks like there's something pointy in there and I say I have a gun, that would be enough.
If you're pointing, then that is a volitional act. You don't have a volitional
So are we
act
parsing
here.
that down now to, I thought he was holding something, he had his hand in his waistband and he said he had a gun, but there's no what there that the jury
That's
can find.
precisely why the court said the standard is not primarily subjective, because there needs to be more. That
She
is
says
why,
he was holding, I saw him holding.
like he got
something.
something in there.
But that's
And then the
part
court-
of, I
But the
believe, what
court
she said.
described what she testified to, described exactly what she's saying she saw, the judge says, and they describe it. And what they describe is the hand is underneath her shirt at her waist. And when you go to cross-examination, she reaffirms that testimony. The leading question is, and then he reached under his hoodie, and she says no. She says no. She says the hoodie covered his hand. She's not describing emotion. We should not, this court
So
should-
what is the import of this testimony she's giving about the hand?
that there's no volitional act, that the record lacks that. And we should not, to go back to Judge Garcia's question, be left with a record like this as a basis for affirming. It's one thing to say it's a reasonable inference in Lopez, because while the stick-up is announced, the hand's placed in the vest. It's another thing to say that the hand is simply under the shirt, and we don't know why, and there's no testimony and no questions were asked about this.
Thank you, counsel.
Thank you.
Mr. Brannigan? What about counsel's argument there's no volitional act?
William Brannigan for the people, Your Honors. Good afternoon. Your Honor, there is a volitional act. The defendant is holding or creating the appearance that he's holding something under a sweatshirt at his waistband where people are known to carry guns. So when he does that, we're also informed by the fact that he repeatedly threatens to shoot the victim. So when she has, as she perceives, that he has a gun, it's reasonable, and what he's doing demonstrates that what he's doing is a conscious effort to show her that he has a gun.
But if the placement of his hand is where one might place one's hand, not for purposes of holding or carrying a gun, how does that affect the analysis in this case?
Your Honor, we look to the circumstances.
I mean, I could put my hand on my hip and people carry guns on their hips, right? It doesn't necessarily mean I have a gun, or I'm displaying a gun.
No, Your Honor. But under the circumstances here, he has his hand under a sweatshirt at his waist. He's threatening to shoot the victim. He's walked into a check cashing place demanding money. Under those circumstances, the reasonable view of the evidence is that he was, in fact, displaying a gun, and that was his intent.
Well, counsel, he was there for a few minutes, right? I think there's some dispute about how long, maybe 10 or 15 minutes. Is that correct, a few minutes?
She said 15 minutes. It might have been shorter. We don't.
So in that 10 or 15 minutes, the witness doesn't say anything about his hand moving other than what she demonstrated, and he's just standing there with the hand by the waistband for that long. Does that suggest that there was a weapon
Yes, Your Honor. Again,
without moving at all?
you don't need to move when you display a weapon like that. I think it's commonly known. He's showing her that he has a gun. He's threatening to shoot her. And again, she's working, she's working her job. She's going through papers that morning. So I don't know who knows what he was doing when he came in. But having that rule, meaning that they had to watch this man the entire time to see exactly when exactly when he put his hand in there, would really disrupt the purpose of the display statute.
But what is the purpose of the display statute?
The purpose of the display statute is to recognize that when somebody displays what appears to be the weapon. One, it places the victim in an enhanced level of fear. And two, it's impossible in the end to demonstrate what he actually had under there. So those are the two purposes of the display statute. And when you look at the facts here and you listen to the testimony, she did not know if she would go home to see her children. That meets the purpose of the statute.
I mean to ask you specifically whether you've looked at the legislative history for the enactment of the display requirement in 1969.
I have not, Your Honor. I'm quoting from Lopez.
Okay.
Continue, counsel.
Your Honor, again, we're informed not only by the placement of his hand, but also by his statement that he has a gun, and by his threats to shoot. So under all these circumstances, there's a reasonable view of the evidence that he displayed what appeared to be a firearm, and this court should affirm the decision of the Second Department.
Thank you, counsel.
Thank you.
Mr. Stewart?
Just to go back to one point that was just raised about the length of time that Mr. Smith was said to be in the check cashing store. That was 10 to 15 minutes, including 5 minutes after Ms. Almeida, who was the employee of the check cashing store, was present, pressed an alarm on the counter, a silent alarm. So he's standing there for 5 minutes after that when he, according to her testimony, notices that she's not going to give him anything and walks out of the store. Empty-handed, no gun ever recovered. He is there for 10 or 15 minutes. He's there as long as I was up here before, and he utters 4 times, "Give me money," and twice, "I have a gun and I'll shoot." That took 30 seconds to say. What's going on for the rest of the time? We don't know. The record is completely silent on that. When she's asked what happened, as I said before, she recites all kinds of things, but does not mention a weapon. She's finally, that's on A32 and 33 of the record. When she is asked about what he was doing with his hands, she said like he holding something, like he got something in there. And the judge says, describe exactly what he was doing. And the testimony is her hand is under her shirt at her waist. As I said, she says the same thing on cross-examination. That is exactly the situation in Mendez. It is exactly the situation. The only distinction in Mendez is that in Mendez, it's a different person who says, I have a gun, or robs, and then says, don't show him the gun. In fact, this is a more compelling case. This is a more compelling case for reversal than Mendez. Because in Mendez, he's at least referring to a gun which is hidden. And there can be little doubt, if you read that decision, you read Lopez and Mendez, that had there been movement of the hand by the man on the stoop, Mendez's conviction would have been affirmed, and it wasn't, because there was no motion. This is that situation. And accordingly, as in Mendez, this court should reverse the conviction for attempted first-degree robbery, substitute a conviction for attempted robbery in the 3rd degree, and remand for resentencing. Thank you, Your Honor.
Thank you, counsel.